Hello and welcome to this VWV seminar on charities and property, the new rules that have been brought into effect with the Charities Act 2022. So to introduce myself, I am Lily Longley. I am a senior associate in our commercial property team in Bristol. I am presenting with Sarah Outram, who is a legal director in our commercial property team based in Bristol as well. Both of us act for primarily charities clients. So we act for a whole range of charities, from very small charities that are not that familiar with dealing with property to the big household name charities and everything in between. So a couple of housekeeping points before we get started. This session will last for around an hour, so we'll finish at around 11 o'clock. There will be time for questions at the end. We'll get through as many as we can. So if you have a question, can you please pop it in the Q&A box throughout the session, and then we'll pick them up at the end. If you have any tech issues, please can you pop it into the chat box and we will try and resolve them for you. We will send the slides and this recording out to you a couple of days after we have finished. So look out for that in your inbox. That's all that's left on the housekeeping points. So let's get started. So what will we be covering today? This will be in 4 parts plus a Q&A session at the end. The first part, I'll be taking you through disposals and what a disposal is when we're talking about charity property. That will lead us nicely on to part 2, which is designated advisor reports. They are needed whenever a charity disposes of property. So I'll run you through what the reports are, what they need to include, who can provide them, and timings for getting them. I'll then hand over to Sarah, who will talk you through the other changes that were brought in by the Charities Act 2022. So that is mainly in relation to connected persons and also the statements that a charity will need to put in mortgages and transfers. Sarah will then chat you through the requirements for when you're dealing with a mortgage and also some post-completion points for acquisitions. So parts 1 and 2 focus on charities disposing of property, and part 4 will focus on practical points for you to consider when you acquire property. If we have time, we'll then go to the Q&A part of this session where we'll answer any of your questions that you have and have popped into the chat box throughout the session. So if we go on to part 1, disposals. Before we talk about what a disposal is, I think it's helpful to take a step back and think about how charities deal with property. So there are 3 main ways that charities deal with property. Firstly, you can own property outright, so that's owning the freehold to the property. Secondly, you can have a lease of property as a tenant. And thirdly, tends to be investment property when your charity owns the freehold and you let that out to a third party. That third party could be another charity or it could be an entirely unrelated for-profit organisation. Sometimes charities are one of these 3, sometimes they're 2, and sometimes they're a combination of all 3. If we're talking about the first category, so charities owning property, that's usually when charities own the property and use it for delivering their charitable objects. So for example, if we think of a charity that deals with the protection of animals and sheltering animals who are in need, if they own property that has stables in, for example, to look after horses, then they would use that property to deliver their charitable objects. Again, the second category, where charities are leasing a property as a tenant from a third party landlord, they tend to use that property as a way to deliver their charitable objects. So again, going back to the example of a charity that looks after animals and shelters them, they would not own the property outright, but lease it from a landlord and use it for delivering their charitable objects. The third category is slightly different because that's usually investment property. So that's where a charity has property and usually owns the freehold to that property. But for whatever reason, perhaps it's not suitable or not fit for purpose, they don't use that property for delivering their charitable objects. And instead, they let it out to a third party, get the rental income in, and put that rental income back into the charity. Because there's those 3 main ways that charities can deal with property, charities and property are therefore closely linked. So we have a lot of trustees on this call for a number of different types of charities. And so it's important for you as a trustee to understand what the requirements are for you when your charity deals with disposing of property. To go on to that then, we need to discuss what a disposal is. So in the terms of the Charities Act, and it's part 7 of the Charities Act that we're referring to here, the meaning of a disposal is pretty wide. So it includes sales, leases for over 7 years, or leases for less than 7 years where a fine or premium is payable. It includes granting or releasing a right, easement, or restricted covenant. So, for example, if your charity is granting a right of way over your land to a third party, that would be caught as a disposal and you would need to comply with the Charities Act requirements. One that often catches people out is granting or releasing a way leave. That isn't what charities typically think of as a disposal, but it is a disposal for the purposes of the Charities Act. So you do need to comply with your Charities Act requirements when dealing with the way leave. I have great sympathy for charity clients when they say to me that often the cost of getting a designated advisor report in the context of the sums involved with the way leave feel disproportionate. I can understand where they're coming from, but for the purposes of the Charities Act, it is still a disposal, so you do still need to comply with those disposal requirements. Similarly, for surrendering a lease, that isn't again something that you would normally think of as a disposal, but it is for the purposes of the Charities Act regime. And the reason it is because if you are a charity tenant that is surrendering your lease, what you're doing by surrendering it is you're effectively giving back your leasehold interest to the landlord. You're giving up your right to occupy that property, and you're therefore saying to the landlord, you can have this property back and you are free to deal with it as you wish. It will no longer be subject to the terms of the charity's lease. Because of that giving back their leasehold interest, the charity is disposing of an interest, and therefore it is a disposal for the Charities Act. So, in summary, a disposal for the purposes of the Charities Act is anything that's not a short lease. By short lease, I mean one that's 7 years or less, with no final premium payable, or a mortgage or a charge. That doesn't mean that if you're dealing with a mortgage or a charge, you don't have any requirements. You do, they're set out in section 124 of the Charities Act, and Sarah will talk you through those requirements later. So I've talked you through what a disposal is. That leads us nicely on to a designated advisor report. So those of you who are familiar with dealing with charity property and disposals will know that when a charity disposes of property, they need to get a designated advisor report. There have been changes to this recently. They were brought in by the Charities Act 2022 on the 14th of June this year. The Charities Act 2022 is not a standalone piece of legislation. It updates and amends the Charities Act 2011, so it's helpful to read them both together. For those of you that have been trustees for a while or have dealt with charity property for a long time, you'll know that the designated advisor reports used to be called qualified surveyor reports, QSRs. You'll still hear people, me included, sometimes slipping back into talking about QSRs. By that, more often than not, we actually mean the designated advisor reports as they are now known. So, what is a designated advisor report? It is a report from your advisor who's acting exclusively for your charity. That's really, really important to know because it actually comes up more than you would think. So, for example, if you are a charity who has taken a lease from a third party landlord and you're the tenant under that lease, if you have underlet the whole of that property to another charity who is your undertenant, and if for you and the undertenant have agreed that on the same day and at the same time, you will both surrender your leasehold interest. So the undertenant will surrender their underlease, and you as the head tenant will surrender your head lease back to the landlord. You could be forgiven for thinking that you could have one report for both you and the undertenant because both of your disposals as a surrender is on the same terms and it's happening at the same time. But in that scenario, you would actually need two designated advisor reports, one for you and one for your undertenant. And the reports would need to be provided by two separate advisors, one that's acting exclusively for your charity and one that's acting exclusively for the undertenant. So if you have a transaction that's a disposal where you have another charity that's involved in that, it's worth thinking, hang on, do we actually need to get two separate reports from two separate advisors? Once you've got the report, you need to read it and consider it. And the idea is that it helps the trustees make an informed decision on whether the terms of the disposal are the best that can be reasonably obtained by the charity. That doesn't just mean best price, it means that the terms in the round the best that can be reasonably obtained for you. You need to carefully consider the report, and only if you're happy that the disposal is on the best terms should you go ahead with it. A practical point worth being aware of is that it's really, really important that trustees record their decision-making process. Whilst we hope that none of your disposals would be looked at by the Charity Commission at a later date, if they are, what the Charity Commission will be looking at is, yes, of course, the final outcome in terms of whether the charity disposed of the property, and if so, to who and on what terms. They'll actually be looking at how the trustees reached that decision. And what they're looking for is processes that are indicative of a board of trustees that actually has properly considered the issue, taken professional advice, and has thought about it in the round. One way to demonstrate that you have actually done that is to have a really good record of your decision-making process. So, for example, that would include having a board minute which sets out when you made the decision to dispose of the property to the buyer that you have found and on the terms that you have agreed with the buyer. That allows you to give that to a charity commissioner or anybody else that may be looking into your decision making process to say, actually, we did think about it at the time and this is how we reached that decision. That's really helpful because often if these decisions are looked at, it'll be a couple of years down the line. So sometimes the trustees that made that decision are actually no longer around. But if you can point back to a board meeting minutes, that will really assist you. The next one is, what does the designated advisor report need to include? So this has been changed by the Charities Act 2022. And to think about that, it's helpful to think about the context of the changes that were brought about. So the changes were brought about by a Law Commission consultation. The Law Commission consulted with those in the sector, so not just charities themselves, but also solicitors and surveyors and other professionals that work in the charity sector. And there was two slightly competing factors that were the main considerations here. On the one hand, there was a recognition that the Charities Act regime was pretty onerous and burdensome for charities. It was viewed as being very bureaucratic with a lot of red tape. It was actually referred to as being equivalent to barnacles on a boat. So there is a want to remove some of those barnacles and make it easier for charities to deal with their property. On the other hand, the Charity Commission and the government were saying, yes, we want to make it easier for charities to deal with disposing of property, but actually we don't want to remove the oversight in its entirety, because if we do, then we're worried that actually some charities could dispose of property not on the best terms or without perhaps properly thinking about it. And because property is a really valuable asset for charities, it needs to be protected. So it is important that certain requirements are met. Those two factors are slightly competing, and they're really helpful context to understand the changes that have been brought in. For those of you that have dealt with the old regime, so before the 14th of June this year, the QSR regime, you will know that the 1992 regulations, which set out what the surveyors needed to include in their report, was quite a prescriptive tick box exercise. And a lot of people did view it just as that. There was a lot of very specific information that the surveyors had to include in their report. Now, under the new regime, we're moving away from that to broad categories. It's essentially giving the advisor more discretion as to what they include in their report based on the specific circumstances of not just the charity, but the particular disposal that they're thinking about. So there is still certain categories that they need to include advice on. They're set out in Regulation 4 of the 2023 regulations. So they need to include the value of the land, any steps that the trustees could take to enhance the value of that land. So for example, if there's small repairs that can be done to the property where the cost of those repairs would actually be less than the enhance in value by carrying them out, the designated advisor should include that in the report. The trustees should consider that and decide whether they're going to carry out those works before they proceed with the disposal. The report should also include whether, and if so, how the land should be marketed. There has been a change with this because the 2022 Act has removed the express requirement for trustees to advertise a proposed disposition in the manner advised in the report. That doesn't mean that the trustees don't have to consider that advice at all. They still have an obligation to consider it, but the specific statutory obligation to follow that advice has now been removed. So that means that if there is a legitimate reason for not advertising the property in the way that the advisor suggested in the report, the trustees have the freedom to make a different decision. The report should also include anything else that the trustees could do to ensure the terms are the best that can be reasonably obtained, as well as anything else the advisor considers relevant. So those 2 points are generally a catch-all designed to allow the advisor to use their discretion as to what else the report should include. There will also be self-certification by the advisor. So they have to self-certify that they have the ability and experience of valuing land to enable them to give the report. So for this, it's helpful for trustees to consider the particular type of property that you're disposing of and the area that you're disposing of it in. So for example, if you're disposing of an office block in London, for example, if it was the charity's head office and they no longer need it, the type of advisor and the experience that they have will be very different to if you're disposing of agricultural land in Cumbria, for example. So you want to have an advisor that's not just used to the type of properties that you're dealing with, offices or agricultural land in that example, but also in the specific area where the property is located. The advisor will also need to self-certify that they don't have a conflict of interest in acting for the charity and in giving the report. So that's covered what they need to include. Let's now move on to who can actually provide them. Again, this is a change that has been brought in by the Charities Act 2022. And I think that this is a really positive change for charities, particularly for smaller charities here, because what the new regime has done is it has expanded quite significantly the pool of advisors that you can get advice from, with an aim of making the regime more flexible for charities, but also so it's quicker and cheaper for them to obtain a report. So you can now get a report from an agricultural valuer, provided that they are a fellow of the Central Association. You can get a report from a estate agent, provided they're a member of Property Mark. That's about 25% of estate agents. You can still get it from a qualified surveyor, as you could under the old regime, provided they're a member of RICS. And crucially, it's now expanded the pool so that charities can also get the advice in-house from qualified trustees, officers and employees during the course of their employment with the charity. If you are going to bring it in-house, then it's worth mentioning that the Charity Commission guidance states that if it is a trustee, officer or employee that's giving the advice, then any conflicts of interest must be properly identified and managed. If the advice is given in-house, the potential for a conflict of interest is greater, and therefore this needs to be identified at the outset and carefully managed. In addition, if a trustee is giving the advice and the charity wants to pay them for that advice, that is okay in principle, provided that the charity's governing document allows for payments to trustees for their services. So before agreeing to pay a trustee for giving a report, you'll need to go back to your charity's governing document and check that it authorises that. You'll also need to follow the legal requirements for paying trustees. So these requirements are not covered in detail in this presentation, but it's worth mentioning so you're aware. If you do come across that, it's something to think about and get advice from. The Charity Commission guidance is also really helpful in this area. So when do you need a designated advisor report? You need a report whenever a charity disposes of property unless one of the exemptions are met. There are three main exemptions. The first is a disposal to another charity for less than best price. So an example of this would be if you have charity A that is merging with charity B. As part of that merger, charity A is transferring all of its property and other assets to charity B for a nominal sum of £1. That's clearly going to be less than market value, and in that case, you could likely rely on the exemption which says you don't need to have a Charities Act report in that case because it's going from charity A to charity B for less than market value. The caveat to that is that the disposal, so in this case the transfer of the properties, must be authorised by the trust of charity A. Another exemption is a lease to a beneficiary of a charity for less than best price, and mortgages are also a third exemption. And it's not that you don't have to have any requirements when you're dealing with mortgages, you do. They have their own separate regime that is set out in section 124 of the Charities Act. Sarah will talk through those requirements later. If you don't get a report when you need one and you don't fall within the exemptions, then you will need to go for the Charity Commission for their consent. What are the timings for obtaining a report? Best practice has always been that a charity needs to get a report before the charity agrees to the disposal. In a property context, you have the disposal itself, which if we're talking about a sale, will be completion of the transfer. If we're talking about a lease, it'll be completion of the lease. But often before you get to the point of completion, you enter into a document, either a contract for sale if we're dealing with a sale, or an agreement for lease if you're dealing with a lease, which signs the charity up to enter into the disposal at a later date. But by signing up to those agreements, the charity is contractually bound to enter into the transfer or the lease at a later date. So because of that, it has actually always been best practice for charities to ensure that they have their designated advisor report before they sign up to that contract or the agreement for lease. Upcoming changes that are coming to effect at the end of the year will come up to speed effectively with that best practice, because they will require charities to put a statement in the actual sale contract or in the agreement for lease confirming that the charity trustees have complied with their requirements under the Act, i.e. they have got a report. That just codifies best practice anyway. You should be doing it now, even before you have to put a statement in, which will come into effect at the end of the year. If you don't comply with those requirements, and as I said, if you don't fall within one of the exemptions, you will need to get Charity Commission consent. You will also need to get Charity Commission consent if the disposal is to a connected person. And again, Sarah will talk you through who is a connected person in her section. And you will sometimes still need to get Charity Commission consent if you're disposing of designated land. There are a few exceptions to that, but the general rule of thumb is that if you're dealing with designated land, you will need Charity Commission consent. Designated land is sometimes also referred to as permanent endowment. And what it is land that has been designated for a specific use. So a common example of that would be if you are a charity that your objects are relating to recreation, leisure and outdoor sports, and you have a field that has been designated for use as a recreation ground, that would likely be designated land or permanent endowment. If that's the case, then certain additional rules and requirements apply to any disposal of that land, and you often have to go to the Charity Commission for consent. So if you're dealing with that type of land, be aware of that and take advice. If you do need to get Charity Commission consent, you need to be aware that it's quite time consuming and can also be quite costly. The Charity Commission, like many public bodies, is underfunded, it is overworked and it's overstretched. So getting their consent is not necessarily always straightforward and can be quite time consuming. Also, it doesn't actually save the trustees in terms of the requirements of getting a designated advisor report, because in order to give their consent, the Charity Commission will need to be satisfied that your charity has got professional advice from someone who's appropriate to give that, so a designated advisor, on the terms of the transaction, on the market value of the property, and they'll also need to see that the charities have reached the proper decision in terms of disposing of the property and be satisfied that that disposal is in the best interest of the charity. So if you're a charity thinking it may be easier to get Charity Commission consent than to get designated advisor report, that isn't the case, because actually the Charity Commission will still want to see a lot of the advice that you would have to get in a designated advisor report anyway. It will just add more time to the transaction. So that has been a whistle-stop tour of designated advisor reports and the new changes to that regime that have been brought in by the Charities Act 2022. I've set out some practical points of do's and don'ts. So in terms of do's, definitely get advice from an advisor early on. That goes back to what the report needs to include, which is marketing advice. And so it's really helpful to have the advisor on board before you actually market the property, because if they say that you need to advise it to market it in a certain way, you want to know about that before you've actually gone to market. As a trustee, it's really, really important that you fully consider the advisor's report. And if you're not sure of anything that they've said or why they've said it or why they've put in a statement that they have, then chat about it with them, have an open conversation about it. It's really important as well that trustees properly record your decision-making process, so that if anyone is looking back at the decision that you made, you can explain and point to why you made that decision and what factors you took into consideration in making it. Do not wait until the end to get advice. There's been a couple of transactions that I'm aware of where we've had charities on the other side that have waited quite late to get their designated advisor report, and it actually just holds things up for everybody and adds unnecessary stress to the transaction. And another practical point is not to confuse an estate agent's valuation with a designated advisor's report. That's really easy to do. So often if you're dealing with property, for example, if you're selling a property, you will get an estate agent in at the beginning to tell you what the market value of the property is, what you can expect to get for the sale. That estate agent's valuation is not the same as the designated advisor's report, and having that valuation doesn't take away the charity's need to have that advisor's report. Although the estate agent, provided they are signed up to Property Mark, could provide the designated advisor's report, their valuation is not that. The designated advisor's report needs to include the specific bits set out in Regulation 4 of the 2023 regulations. So I'm now going to hand you over to Sarah, who's going to talk you through the other charity property changes in the Charities Act 2022.
Thanks very much, Lily. Hello, everyone. So Lily's run us through the designated advisor, and you'll see that this table sets out the Charities Act changes that that's been coming into force in relation to the Charities Act 2022. So the Charities Act 2022 received royal assent on the 24th of February last year. Implementation was already designed to be in stages, but this timetable is slipping. So stage 1 eventually came into force on the 31st of October. Stage 2 was delayed by quite a long way, and then finally came into force on the 14th of June this year. Stage 3 was, it might be the start of 2024. So with that, the reason for the delay in that is mostly because they're working with the land registry and all sorts of implementation issues. So Lily's dealt with point 1 of this table. Line 2 is around connected persons. So prior to this, all employees were connected persons. And you'll see why this is important for those of you who have any members of staff who you grant property ASTs to, so assured short-hold tenancies. One of the crucial things they've changed is that employees are now removed from this list so that you can grant a 12-month tenancy for maximum for an employee without the need for any consent from the Charity Commission. And that came into force in June this year. And then, as I say, I'm going to cover the tranche 3 changes. So what is a connected person? There is a detailed list in the Charities Act, but it includes your very common sense set of people. So a charity trustee or a family member of a trustee, a person who donates to, money or land, somebody who is employed by the charity or is a officer, and then a spouse, civil partner, or business partner, which is probably the slightly wider range of everyone in the above. What that means is if you are needing to grant either transfer property in between those people, so in Lily's examples, you know, your freehold or your lease between those people, granting a lease to any of those people, you will need to go and get consent from the Charity Commission. The majority of the ones that we do are related to trading subsidiaries because they are essentially owned by the charity. They are generally relatively straightforward to obtain permission for. There aren't too many questions that get raised by the Charity Commission, but a scheme is required, and there is a knock-on issue in terms of timing to get those sorted. It can take quite a long time to get the process, to get a scheme, and therefore it's sensible to start the process ASAP. The big change is that the grant of a residential tenancy for 1 year or less is no longer caught by this section, which is a really great relief to those people. I know we've got a number of schools on the call who grant tenancies to employees. There's a difference between service occupancy agreements, so where it's required for the better performance of your duty. These are tenancies, which are technically disposals under the Charities Act, and they're the ones that's caught. So as Lily said, there are a number of statements that are required. They are going to be updated in tranche 3, and we are waiting to see exactly what those will look like. We can't imagine they're not going to change a huge amount, but the reason why tranche 3 has been delayed is because they need to speak to the land registry and make sure the land registry is on board with all of the changes. It will affect all disposal and acquisition documents that are registered, and therefore we understand this is the reason for the delay. So at the moment, the statement says that the land is held either in trust for or is held by the charity for, which is a non-exempt charity, i.e. one that's registered at the land register, registered at the Charity Commission. And this transfer is not one falling within one of the permitted disposals under the sections of the Charities Act, and therefore the restrictions apply. The crucial one, as far as you as trustees are concerned, is point 2. So this is a certificate that the trustees need to give in the disposal document to say that they certify they have the power under its trusts to affect the disposition and that you've complied with the provisions of the Charities Act. And this includes going to get all of those statements and making sure that you've got the designated advisor reports. You don't need to know about these. Your lawyers will put them in documents. It's just to let you know that these are what you will need to be certifying as part of your disposal documentation. So I've got some top tips where we're dealing with legal charges. So legal charges that charities need to take out are often in two categories. So you might have a loan from a bank in order to purchase the freehold of a property. So you might be buying an investment property that you want to obtain a mortgage over. But alternatively, you may be looking at a facility agreement with a bank which gives you the provision of an overdraft, and they will, which will be summed from time to time, and they will want to secure that over your property. Now, that could mean that actually there's very little that's owed to the bank, or it could mean that there's, a big development loan. The process for both is the same. So one of the things that we often find is that banks aren't necessarily that au fait with working with charities. So one of the things that we always check first is that the bank standard documents and resolutions are often incorrect. So one of the big things that we have to get them to do is update those and making sure that the references to the charity are correct. The Charities Act, sections 124 to 128, governs the charity's obligations when taking out a loan to be secured over property. They are similar to the disposal rules, but it includes other things like the charities need to consider, is the loan necessary? Are the terms of the loan reasonable? And are the trustees happy that the charity has the funds or strategy, business plan to be able to repay the loan? It needs to be reasonable for the charity's purposes in order to take out. And as with a disposal, this needs to be documented so that people can look at it in the future and it's minuted correctly. The advice, it needs to be from a designated advisor. However, it's somebody who is reasonably believed by the trustees to be qualified by ability and has practical experience of financial matters. I therefore foresee that a lot of people might use employees if you've got somebody in-house who's qualified enough to provide that, or it could be an accountant. So rather than needing to go to the slightly more estate agent surveyor's side, it's really a designated advisor that the trustees feel have the ability and is a reasonable person to be providing the advice on the terms of the loan. They also must not have any financial interest in a loan and must give the same practical information that Lily suggested around making sure that you deal with any conflict of interests properly. In respect of acquisitions, which isn't something we've really talked about for today, so this is where you're acquiring land, so you're buying it, taking a lease. There is a threshold by which an SDLT return, so stamp duty land tax return, is required. However, a charity is able to claim relief if provided within 3 years of the transaction, if the owner of the property stops being a charity or uses the property for purposes that are not charitable, HMRC can claw that relief back. So what we will always do if we were acting for you, is that we'd always provide you with a return. We'd submit that on your behalf, claiming the full relief. And what you just need to make sure is that within 3 years, if any of those things happen, be aware that HMRC can claw that relief back. The return is still required within the 14-day period, like any other return. It's just that tax is not actually payable at the time we submit the return. And then in respect of the land registry, your lawyer will help with this. So it's really not something for you to worry about, but just to let you know that there are standard restrictions that you'll put on a registered title, and you might see that on your own titles if you've ever needed to look at them. And it essentially says that you're not allowed to dispose of your land without making sure that you've complied with the requirements under the Charities Act. And also because this is a slightly more complex area of law than another straight residential house purchase, we do typically receive more questions from the land registry. Sometimes this is around signatures. Sometimes it's around the land registry really trying to understand exactly how we've done this and to make sure that we have complied with the Charities Act in the right way. So we often do get more questions from the land registry. But again, your lawyers will hopefully deal with that for you. What I often guide my clients to are some really, really helpful Charity Commission guidance. And we're going to send you this slide afterwards with the links in so you can look at them. The Charity Commission has, as you can see, tens of update on their website that have now been updated post the Charities Act 22 and will continue to be until the last tranche is installed later this year / early next year. They're written in plain English for trustees, but there are some really helpful ones that we signpost our clients to on a fairly regular basis. So there's CC3 is essential trustee guidance. So managing your charity's resources, which includes managing your land. So this is what you need to know. How do you do it? There's then a really helpful one, probably I use more than others, and certainly signpost to clients more than others, is guidance on sales and disposals. This really clearly sets out if it's a short-term disposal, is it a long-term disposal, include some of those questions around, do I really need a report for a way leave or a grant of an easement? It also includes the information that we've been talking around the advisors and what their jobs are, and includes some information about mortgages. So that's a really crucial one, and it's helpful to know that it's there. I'm not expecting you all to go and sit it and have it as bedtime reading, but it's just really helpful to know that there is the guidance available. And then there's one on acquiring land. The rules aren't quite the same in relation to reports. No reports required, but it's about understanding what a charity is, that they're getting best value and best terms that can reasonably be obtained for that land, and therefore there's some helpful guidance on that. There's other guidance we use, but I haven't linked specifically to it. But for instance, if you've got land which is owned by the official custodian for charities on behalf of the charity, if it's an unregistered charity, then there's separate guidance about that as well. So I hope that's been helpful. I can see we've got a few questions. If anyone else has any others, do feel free to put them in the Q&A box. Lily, have we had any, you had a chance to have a look at them?
Yeah, so thank you very much for those of you that popped some questions into the box. The first one is, I understood that a designated advisor's report should be obtained before going to market. Is that correct? That's a really good question. So the technical answer is that under the regime and the changes that are being brought in, it will need to be obtained before you enter into the instrument that will agree to the disposal. So in my example earlier, that's before you enter into the agreement for lease or in the contract for sale. Having said that, best practice is absolutely to get it before it is marketed. The reason for that being the report needs to include advice on how the property is marketed, and therefore to know that you actually should have the advisor involved from a very early stage and before you market. Practically speaking, what I say to clients is if you get your advisor on board really early, so before you market the property, back when the very early decision making stage, so when the trustees have decided they want to dispose of the property, for example, they've agreed they want to sell the property, get the advisor on board then to help you with marketing. Get them to discuss with you the terms of the disposal and not just the market value, but what other terms you should be going for. They can provide you with a draft report, and most previously surveyors, but most advisors are happy to do this. The draft report gives you advice on how you should market the property. And then before it actually comes, just before you're actually due to enter into the contract for the sale in this example, they then submit the final report. So you have it just before you actually enter into the contract for the sale, but actually there's no surprises in it because you've had the draft report a couple of months before at the very beginning of the process. So yes, best practice is definitely to get a draft report and to get the advisor on board early before you market the property. The next question is a family member of a trustee automatically a connected person? Yes, so a connected person is a trustee or a child, parent, grandchild, grandparent, brother, sister, spouse, or civil partner of a trustee. So, yes, they would be. And the final question that we've got so far is we've got a statutory power to dispose of land and to grant easements, licenses, etc. I'm assuming the exemption in section 1173A of the Charities Act still applies, and we don't have to get a designated advisor report, although we obviously get advice on value so that the trustees have adequate information for decision making. Yes, provided that the statutory power that you've got applies either generally or grants special authority for the specific dispositions that you're talking about. So in these cases, the easements and other dispositions, and that falls within that exemption. That then means that you don't need to get a designated advisor report. But as you say, it's still prudent for the trustees to get advice on value and things. So it sounds like the trustees are doing everything they need to there, and provided that the statutory power applies to those specific dispositions or gives a general power for those dispositions, then you fall within that exemption.
And it's worth saying as well that you'll have a slightly different statement. So the statements that go into the disposal documentation will be slightly different if you do fall within one of those sections. And so that would just that we'd tweak that as lawyers to make sure that that's covered.
That's all of the questions in the chat box that we've had. Has anyone else got any other questions or thoughts about it? So thank you, Bob. So Bob's saying, as a small charity, we vested custodial trustee in our parent charity. Since then, we've become a CIO. Does our parent charity still act as custodial trustee for our charity?
That will depend on what happens on the CIO. So if, for instance, that transferred over to the CIO, and we'd need to do a bit more double checking with it specifically, but it will depend on what happened when that CIO was incorporated and whether or not that was transferred at the same time. So yeah, I mean, if anyone does have any specific questions, then please do let us know. We've got our contact details. Lily and I'm more than happy to answer any questions. But thank you so much, everyone, for coming, and I hope you will have a fantastic rest of your day.
Thank you very much.